Oh, I got Mr. Malaro back. All right, Rhonda, I'm gonna close the breakout room and bring Mr. Derby back. Miss. Where'd you go? All right, Mr. Derby, go ahead and unmute your device, please. All right, this is in the matter of the people of the state of Michigan versus James Edward Derby, file number 2023-21594FH. I have Rhonda Underwood appearing on behalf of Mr. Derby, and I have Amanda Wagner appearing on behalf of the people. Miss Underwood, how would you like to proceed with Mr. Derby today?
Your Honor, the plea offer at this time is that Mr. Derby would plead to an attempted resisting and obstructing, and the felony and the habituals would be dropped. Mr. Derby needs a little time, Your Honor, to discuss that with me. It's a recent offer. So I would ask for a very quick adjournment on this matter.
All right, Mr. Derby, can you unmute your device for me, please? He's not, he might not be able to. Okay, so my next available is February 7 at 8:30, Miss Underwood.
That's fine, Your Honor.
All right, and if you can do the stip in order to adjourn, Miss
I will
Wagner.
do so with Ms. Wagner's permission.
Yes,
Okay.
yes, Judge, that's fine. I guess I would like to just place one quick thing on the record. This is not a new offer. It's the same offer that we discussed on the district court level. And I advised Ms. Underwood on the record downstairs that the offer would expire as of the first circuit court pretrial date. I suppose if you're needing more time to discuss that with Mr. Derby, then I'll hold it open until the next pretrial date of February 7th, but it will definitely expire as of that date.
I apologize, Ms. Wagner. My notes said as charged in district court.
Okay, we discussed it the day of the exam when Mr. Derby decided to waive, but that's fine. I just wanted to put that on the record that I guess I'll keep it open until February 7th now, but it'll expire as of that date.
Thank you. That's why I reached out and asked if you had spoken to the firemen.
All right, thank you. So Mr. Derby, you're all set. We'll see you back February 7th. Call your attorney, okay? All right. Okay, so I'm gonna remove him. I think he can't, he might not even be there. I don't know. Okay, so Mr. Daly, we're waiting for your guy. Let me look at my list. Miss Underwood, are you done in front of Judge Olsaver?
Thank you, Your Honor.
Are you done in front of Judge Olsaver, Miss Underwood?
I'm sorry?
The only thing I have left with you is your inmate. Are you coming over to see him?
Yes, yes.
Okay, I'll see you in a few minutes. He's on the 3rd floor.
I'm on my way.
All right, good. Thank you. Okay. Mr. Malaro, Mr. LeFrance is at the jail. Oh, Mr. Malaro, I have Mark Stevens. Well, I don't have Mark Stevens, but maybe you do.
He should be in jail, Judge.
Well, My jail list is not
Did you let him
very
out?
good. I don't know. My jail list is not very good today.
Judge, do you have Bixler down for a pretrial too?
I do, and he's in jail. I'm sorry. I seem to have a lot of people in jail today,
Uh-huh.
but I'm
I
gonna
don't
do yours next. So I got Zachary Ladd, and then we'll do Mr. Bixler.
All right. I don't even know if we need Mr. Bixler, but okay.
Okay. Isn't he, So Mr. Bixler is set for jury trial February 5th, right, Mr. Daly?
Yes, but I believe the prosecutor is going to want to file some.
Hold on,
that.
Mr. Daly, hold on. I'm sorry, do you know if, let's see his name, if Mark Stevens is in jail still?
Oh, I can look real quick.
Why did I get the jail nurse? I think.
Oh, well, I can pick up from in here, so.
Oh, okay.
Hold on one second.
Okay.
Your Honor.
All right, I'm sorry, Mr. Daly. I can call the case, but we can take Mr. Bixler next if you want him.
Whatever the court wants to do doesn't matter to me.
All right, so they offered a new plea, so you're gonna go meet with Mr. Bixler?
I don't think there's not going to be any pleas on Mr. Bixler. I think the prosecutor is going to file some motions, in particular a 404 B motion.
Okay, so this is in the matter of the people of the state of Michigan versus Ricky Nelson Bixler, file number 23-21315 FC. Everybody pause. Nope, the jail didn't pick up again. Hold on. Hey, this is Judge Anzalone. I just talked to somebody about, is Mark Stevens in custody still?
I'm sorry, you cut out a little bit there. What was that name?
Mark Allen Stevens Jr.?
Stevens Jr.? Yes, we still have him.
Okay, all right. I needed to know that. Thank you.
Yes, ma'am.
Bye.
Bye.
All right, I'll add him to the jail list. I have James Daly appearing on behalf of Mr. Bixler and Jacqueline Weiss appearing on behalf of the prosecutor's office. So Mr. Daly believes that you're gonna be filing some motions, Ms. Weiss?
I filed my 404B notices last week. And I sent those to Mr. Daly as well, and he said he would be filing an objection to those. So I don't know if we need to have a hearing on those 404B motions prior to the.
I don't think it's going to be a complicated issue, Your Honor. The prosecutor wants to add witnesses from 30 years ago, and she's going to base that upon the fact that he has been incarcerated for those 30 years. I would suggest to the court that he's been receiving rehabilitation and cooperating and hasn't been in any trouble. But in any event, that's what she's going to want to put in. I don't even know if a brief is necessary on that, because that's a pretty basic question.
So why don't we do this? Trial's February 5. Why don't Ms. Adams, looks like I probably need, are you gonna file a written objection, Mr. Daly?
I will.
All right, so will your staff, do you waive any notice restraints on that, Ms. Weiss, so we can hear it before the trial?
Yes.
All right, so Mr. Daly, just have your staff call and get a date from Ms. Adams prior to the trial, okay?
Okay, I will do that, Judge.
All right, so we'll continue Mr. Bixler to trial.
Okay,
All
thank
right.
you.
Thank you. And then, Mr. Ladd, can you hear me?
Yes, ma'am.
Okay, this is in the matter of the people of the state of Michigan versus Zachary Lawrence Allen Ladd. We have file number 22-21116FH and 23-21646FH. Mr. Ladd is represented by Mr. Daly, and I have Isaac Sneed appearing on behalf of the people. So, Mr. Daly, how would you like to proceed on behalf of Mr. Ladd?
Your Honor, these last few cases just came in, and there's some more that haven't been processed yet. Mr. Ladd wants to enter into a plea bargain, and he wants to resolve all of these matters and get on with his life. but we don't have all of the files yet, and I think there's still some more coming. All I don't need an adjournment for anything, but to get an indication from the prosecutor that we now have all of the files together, and this is once the plea bargain is. Once I have those things, we're ready to resolve this matter.
All right, Mr. Sneed, is there any assistance you can offer regarding that?
Sure, I believe we have all that information. Ms. Wagner and I have worked out a plea offer just recently, so I believe more time for Mr. Daly to review that with Mr. Ladd would be appropriate. Thank you.
Okay, how far out would you like an adjournment, Mr. Daly?
It depends on when I get the plea offer. As soon as I get the plea offer, I'll be ready.
So why don't I set this out to February 21? If you get a plea no, hold on, Mr. Ladd. So Mr. Daly, if you get the plea offer and he decides to avail himself of it, if you just call my office, we'll get you in that week.
Very good. As soon as I get
Mr. Ladd, that's like my next available date. But Mr. Daly brings his people in on other days. So if there's a plea offer that you want to accept, Mr. Daly will call my office and we'll get you in right away for a plea, okay?
Yes, please.
Okay, so I'll set it, set it for February 21 at 8:30. And then if not, I'll see you sooner, Mr. Daly. Anything else?
No, I just want to let Mr. Ladd know that I'll be over there as soon as I get the plea offer from the prosecutor.
Okay, and all right, so thank you. All right, Mr. Ladd, could you do me a favor? And could you let them know that I would like to see Mr. You do not want Mr. Bixler today, Mr. Daly?
I think we just resolved that issue. I don't think we need him now, Judge.
Okay, so how about, Mr. Ladd, if you could let them know that I would like to see, let me see, hold on, give me a minute. How about Anthony LeFrance? Can you let him know I'd like to see Mr. LeFrance?
That's right.
All right, Mr. Malaro, you're good.
Hey, Judge,
Yeah.
did you tell Rhonda something earlier about Darnaz Johnson?
Yeah, he's in person because MDOC didn't fingerprint him, which, so I ordered that he be here in person. So he's on the 3rd floor. So she's coming over to talk to him and then she'll.
Okay, and then Mr. Lepper was another MDOC one. Are we still waiting to do him as well?
Let me find him on my page. Lepper.
Lepper, Lepper.
So I don't have him on my docket.
Judge, that got adjourned to January 24th. I think MDOC couldn't accommodate. It was the reason.
Okay.
Because, okay.
He's in person.
And then Mr. Warner, we're still waiting for him from the jail. He was at arraignment that we. Oh
yeah, he's in jail and we didn't know. Okay. So I need to add Warner and Stevens.
I just wanted to double check.
No, yeah, Warner and Stevens. Okay. He's down on that other end.
He's down there in a holding cell.
How long is that?
You can lock the courtroom, take her back. All right, I'm live on YouTube, so we can lock the courtroom. We're gonna lock the courtroom and he'll take you down to visit. Oops, let me take these to Becky. I'm just gonna hand these to Becky. Just bring them on. She's such a new judge. There's a difference, man. I'm Julian. Nice to meet you. You go to school, Adrian?
What is your college or college? College. Okay, good.
Good day to the guys.
Mr. Bixler wasn't on from the jail when they talked about that. Okay, thank you.
All right, hold on. All right, what is your name, sir?
My name is Anthony LeFrance.
Hold on. Mr. Malaro, let me grab your client's file. So this is. I am so sorry. What did I throw at you? All right, see, sorry. Well, I almost injured my court recorder. Nothing to see here. All right, so sorry.
You're fine, Judge.
So this is in the matter of the people of the state of Michigan versus Anthony Wayne LeFrance, also known as Flores, file number 20-20096 FC and 23-21622 FC. I have Salvatore Malaro appearing on behalf of Mr. LeFrance, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set. Is somebody down there watching her?
Yeah, there's 2 guards down there.
But they can't unlock the door, can they?
Bill's down there.
Good, good. All right, so, Mr. Malaro, how would you like to proceed with Mr. LeFrance today?
Your Honor, I'd like to adjourn this for another pretrial, but we're really close to getting a plea in. I had some matters occur over the last few weeks that prevented me from getting over to talk to Mr. LeFrance to finalize things. So that would be.
You said I can take my plea.
So, Mr. LeFrance, Mr. Malaro just would like it adjourned like a week or so that he can come talk to you about the plea.
I already know the plea. You already told me. I might as well, I'd take it today.
Well, Mr. Malaro, what is the plea offer? Or Mr. Sneed or somebody, what is the plea offer from Mr. LeFrance on 23-21622?
Judge, go ahead, Isaac.
Well, I have the plea offer of 48 months on the minimum, 24 on the felony firearm and 24 on the assault GBH. Let me get the exact terms there.
All right, hold on, Mr. LeFrance. I swear to you, that's never happened.
No, that's fine.
I'm bringing up the plea form now, Judge.
It's okay. Mr. Sneed, while you're doing that, I'm going to put the court, I'm gonna stop for a minute, like 2 seconds. I'll be right back. early, because I don't have heat up there.
Yeah.
All right, Mr. Sneed, whenever you're ready.
Having some technical difficulties, Your Honor. So if we could just pass it for like a minute or 5.
Well, if I may, Your Honor.
Sure.
So I hadn't talked to Mr. LeFrance about the minimums, and that's what I wanted to talk to him about. And that's the basis for me. I know Mr. LeFrance is eager to get this matter resolved, but I had some things occur that last few weeks that prevented me from getting over there. But that's what I want to do.
So, Mr. LeFrance, the plea offer requires some minimum prison term sentences. So, Mr. Malaro would really like to talk to you about it. So, Mr. Malaro, would you be able to do that in the next week?
I could either do it tomorrow or Friday, Judge.
All right. So, what I'm going to do, Mr. LeFrance, is set this over to next Wednesday, just one more week, and that will be January 24 at 8:30 in the morning. Mr. Malaro, if you talk to him and he decides, don't go anywhere yet, Mr. LeFrance. If he decides to avail himself of it, just call and we'll get him in right away. All right.
Yes, Your Honor.
All right. So, Mr. LeFrance, he's going to do the stip in order to adjourn. And then we'll see you back next Wednesday, if not sooner. But Mr. LeFrance, could you let the jail know that I need to see, hold on. Let's see who represents. Hold on, Mr. LeFrance, don't go anywhere. I gotta find. Could you tell them I'd like to see Mark Stevens next?
Mark Stevens
Yes, sir.
or Bob?
Mark Stevens. Just tell them, don't hang up, don't disconnect, leave the window up. But when you go out, tell them I would like to see Mark Stevens next.
Alrighty.
All right, thank you. And you'll do the stip in order to adjourn, Mr. Malone.
Mark Stevens.
There's a bop there too, Sam.
Yes,
Mr. LeFrance.
Yep.
Mark Stevens. Son, get his ass over here.
And Becky, if you wander in, I'll take that civil file too. Let me check. I don't have Tate, Warner, Haybecker. Is it Mulata? I think Haybecker got settled, but I must have given you back statements. Have you seen the new pods, Mr. Malaro, that they're using from the jail now?
No.
I've had a couple of them the last couple of days. The audio is amazing on those.
Oh, good. Yeah, I know they're installing something, but I didn't see what they did.
There's like 8 of them.
Yeah, I know. Which is awesome.
It's like a recording studio.
Yeah. Which you're singing, so you're prepping for that, right?
Yeah. All right, you guys have a good day.
All right, thank you. so Miss Adams. Oh, all right, sir, what's your name?
Steven?
All right, good. Yeah, good, thank you. Let me grab your file. So this is in the matter of the people of the state of Michigan versus Mark Allen Stevens Jr., file number 23-21605 FC. I have Salvatore Malaro appearing on behalf of Mr. Stevens, and I have David McCready appearing on behalf of the people. This is the date and time set for pretrial in this matter. Mr. Malaro, how would you like to proceed today on behalf of Mr. Stevens?
Your Honor, Mr. McCready and I kind of reworked the plea, but if I could have like a 2-minute breakout with Mr. Stevens to make sure we're all on the same page, I would appreciate it.
That's fine. All right, so Mr. Stevens, I am going to open up a breakout room and give you a chance to speak with Mr. Malaro. So go ahead and click on join that breakout room. All right, Mr. Malaro and Mr. Stevens, we are back on the record. So, Mr. Malaro, how would you like to proceed with Mr. Stevens today?
Your Honor, I believe we have a plea agreement in this matter. And I think the plea is as follows. And Mr. McCready can correct me if I make a mess of it. Mr. Stevens is going to plead guilty to criminal sexual conduct, 2nd degree. There's a Killebrew agreement to 6 months jail with probation, and that the SORA registration requirement will be for 15 years. I believe that is our plea agreement. Hopefully I got it right.
That is correct.
Okay, so he'll plead to they're going to be an added count 5.
Correct.
Okay, so he's going to plead guilty to count 5, criminal sexual conduct, and the second degree. Do I have an amended information already or no?
We're working on that now, Judge.
And the maximum penalty on that is 15 years?
Correct.
Okay, so, and then there's a Killebrew to 6 months in Lenawee County Jail. And what was the other term, Mr. Malaro?
Probation and then a registration requirement of 15 years under SORA.
Okay. Okay, so, Mr. Stevens, do you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Right, can you state your full name for the record, please? Okay, so you can put your hand down. So Mr. Stevens, this is not your fault. That room has horrible audio. And what happens is when you talk, it kind of echoes around the room. So I'm gonna need you to scoot up. Yeah, scoot up closer to the device. Okay. So you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 5 criminal sexual conduct, second degree, which carries a maximum penalty of up to 15 years in prison? But there's a Killebrew agreement between the prosecutor and the defense attorney that you will serve 6 months in Lenawee County Jail. You'll be placed on probation, and then you'll be on the sex offender registry for 15 years. So do you understand that agreement?
Yes. Yes, ma'am.
Okay. Do you understand though, once you're on probation, if you violate probation, you could go to prison. Do you understand that?
Yeah.
Okay, good. Now, are you satisfied with Mr. Malaro and the advice that he's given you?
Yes, ma'am.
Okay, and it's your intention to plead guilty to that charge, sir?
Yes.
All right, so other than the agreement that was placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
And Mr. McCready?
Correct.
Okay, and is that correct as far as you're aware, Mr. Stevens?
Yeah.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have heard at or had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial if the prosecutor and court agree, and then you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that any appeal from the sentence or any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? So that means you would have to apply for an appeal. And whereas if you had gone to trial and been convicted, you would have had an automatic right. Do you understand that?
Yeah.
All right. And do you understand that any appeal, let me see. So Joanne, I'm going to go back up a little bit just because I was thinking I need to tell Miss Adams to bring me the 2024 book, please, the red book. So then I lost track because I didn't focus. So you understand you're giving up the right to any appeal issues that would be appealable if you were convicted at trial. Do you understand that?
Yes, ma'am.
And you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right.
Yes.
And you understand if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that?
Yeah.
And you understand once you enter this plea, you will be required to register as a sex offender under the Michigan Sex Offender Registration Act for 15 years. Do you understand that?
Yes, ma'am.
If you fail to register as ordered, that can result in another felony for failure to register. Do you understand that?
Yes.
Okay. Do you have any questions about the rights that I've given to you?
No, I don't.
All right. So, Mr. Stevens, how do you wish to plead to the charge that on or about August 8th of 2023 in the city of Adrian, in the county of Lenawee, that you did commit the offense, criminal sexual conduct, second degree, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge other than what was placed on the record?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes, I understand.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Mr. McCready?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimate what your sentence will be other than what was placed on the record, Mr. Stevens?
6 months.
Okay. Is it, say that again, Mr. Stevens?
That's all I know is 6 months.
Okay. Is it your own choice to plead guilty?
Yes.
Okay. So, Mr. Stevens, on or about on August 8th of 23, were you in the city of Adrian in the county of Lenawee?
August 8th. What time? What year?
So, August 8th of 2023, on or about that day? So, we're talking about the day this occurred, Mr. Stevens?
Oh, yeah.
Okay.
Hey, I'm
So,
sorry, I'm just slow-minded.
no, it's okay. It's okay. So on August 8th of last summer of 2023, were you in the city of Adrian in the county of Lenawee?
Yes, I was living with my dad.
You were living with your dad. Okay. And at that time, did you come in contact, and we don't say their names, okay? So I'm just going to say a victim, okay? And did you come in contact with a young woman at that time who was between 13 but not yet 16?
Not 13.
Was she over 13?
Yes.
Okay, would you agree she wasn't yet 16?
Yes.
So she might have been 15 or she might have been 14. Do you agree with that?
15, that's all I know.
Okay. All right. And then did you insert your penis into her vagina?
Yes.
Okay. All right. And that was for your own sexual gratification, correct?
Yes, ma'am.
All right. Mr. McCready?
And it was also, he shared marijuana with her at that time.
He didn't plead to that.
Well, can I step in here?
Yeah.
Okay, Mr. Stevens, is it true that an Ethan Terrell helped facilitate the sexual contact with the victim?
Yes.
Okay, and you had reason to know that with his self, that and her being underage, that she was not physically capable of resisting
Yes.
advances?
Yep.
Does that satisfy the state and the court?
People are satisfied.
Okay. I'm sorry. I don't have the felony information, so I didn't know it needed that. All right. Are you satisfied now, Mr. McCready?
Yes.
Has the court complied with MCR 6.302 B, C, and D? Mr. Malaro?
I believe the court has.
Mr. McCready?
Yes.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than honoring the Killebrew plea that was struck between the prosecutor and the defense attorney. I'm going to refer this matter to the probation department for a pre-sentence investigation. We will set sentencing for March 22nd, at 8:15 in the morning. Mr. Stevens, someone from the Michigan Department of Corrections, a probation officer, is going to come over to the jail and meet with you. When they do, they're going to ask you questions about your background and also the events that occurred. Be truthful with them about your background. Be truthful about what happened that day. They'll prepare a report. We'll get a copy of that report to Mr. Malaro, and he will review that with you before the day of sentencing. And then we will see you back on March 22nd at 8:15. Now, you have the right to be present in person for sentencing, but you could also Zoom. So it's up to you. Do you want to be in person or do you want to Zoom?
Zoom.
Okay. All right, so we will make that Zoom and we will see you back that day. So, Mr. Stevens, could you do me a favor and let the jail know I'd like to see, hold on, Denver Warner. Can you tell them I'd like to see Denver Warner?
Denver Warner?
Denver Warner, yep, thank you.
You're welcome.
All right, so from the jail, I had Ladd, LeFrance, Knobloch, Tyndall, Bixler, Davis. So I believe Warner is the last one I have in jail, and that is Matthew Murphy's. And Ms. Hennigan, after that, I will see Mr. Tate.
Understood, Your Honor.
And the probation office told me that he entered a plea in Hillsdale and he's pending sentence on that one, all right?
Yes, thank you.
And you probably want the felony information or the violation paperwork, right?
I have it. Becky sent it to me. She's amazing.
Yeah, she is a rock star. I don't know what I would do without her. Probably walk around in circles.
Your Honor, with your permission, may I log out?
You can, hold on, Mr. Malaro, wait, before I let you log out. Let me look at one more thing. Hold on. So,
Holding.
hold on, Mr. Malaro, one more thing, hold on.
I'm holding. I had my potty break, Judge. I can hold as long as you want.
Right, but hold on one second. All right, are you Mr. Warner?
Yeah.
Okay, good. This is in the matter of the people of the state of Michigan versus Denver Warner. It looks like we have one file, 24-21676FH. I have Matthew Murphy appearing on behalf of Mr. Warner. And this is the date and time set for arraignment in this matter. And I have probably, I'm going to go with Chris Fleming appearing on behalf of the people. So, Mr. Murphy, do you waive the reading of the felony information?
Yes, Your Honor, we waive a reading of the information. We acknowledge receipt of said information, the witness list, and the discovery request from the prosecution in this matter. We're asking the court at this time just to continue and enter a not guilty plea, set a pretrial in this matter. I was going to ask if we could address bond.
All right, so how far are you looking for a pretrial?
Whatever fits the court's schedule best.
All right, you can
Month and a half or so.
Brought down. Brenda's zooming in, hold on. Miss Underwood, I'm gonna have the MDOC prisoner.
I was looking to see if Ms. Meir was in your Zoom, Your Honor.
No, but I'm gonna have the inmate brought down from MDOC. Miss Underwood, do you want the inmate brought down from MDOC?
I've spoken to Mr. Johnson and I wanted to speak to Ms. Meir for a minute, but.
So do you want the inmate brought down yet or no?
I'm sorry, I can't hear you, Your Honor.
I know. Do you want?
I'll be right down.
Do you want the prisoner brought down? All right. Yeah, he's on his way. Don't worry about it. Okay, so, how far out did you want a pre-trial, Mr. Warner?
Mr. Warner wants a pretrial about whatever fits the court schedule best, a month and a half or so.
About February 21.
Yes, Your Honor.
All right, so I will set a pretrial for February 21 at 8:30 in the morning. And because it's arraignment, my staff will do that. I will enter a plea of not guilty on behalf of Mr. Warner. Mr. Warner is charged with aggravated domestic second offense. Wait. Okay, second offense, and then a habitual offender third offense notice. So he's looking for about a 5-year prison term if convicted at sentencing. He can sit there for right now. Just leave him right there for now until we get Miss Underwood. So he's fine wherever he wants, actually. If he wants to go over there, he can go there. All right, so all right, you can address bond, Mr. Murphy.
Your Honor, since the case was at probable cause down in district court, my office, my investigator has spoken with Ms. Holbrook, the victim in this matter. She had indicated, obviously, it's up to the prosecution to continue the case or not, but she had submitted paperwork for it to be dismissed. She had indicated that Mr. Warner is the father of her child that she's pregnant with, and she was asking for the no contact. She was asking our office to try to address the no contact. Obviously, we relayed to her to talk to the prosecutor's office and gave her information for John Bailey. I'm not sure if she, again, my understanding was that she was talking to the prosecutors, that she relayed this to the prosecutors, which is the reason why I'm bringing it up right now. If she hasn't, then obviously that leads us in a different situation. But I am asking for the court to consider a PR bond in this matter because Mr. Warner did spend, this incident did occur back in I think it was October 30th. He did get a violation of probation down in district court. I'm sorry, Mr. Warner, was there something you wanted to?
My paperwork never said anything about a phone.
It said what? I'm sorry.
She had said something about a phone and me sentence, I could do prison time.
Yeah.
My paperwork only said that it was a second.
Now that it's up in...
It's in circuit court now, and your count 1 is domestic violence aggravated. And that's a 1-year misdemeanor, but it's the second time you've been charged with an aggravated, which makes it a 5-year felony. So potentially you could be looking at 5 years in prison. But he's not asking for you to plead today. Your attorney is asking me to release you on a PR bond. Mr. Fleming, any response?
Judge, I don't know much about this case, to be quite frank with this court. I'm just covering it at this point. I didn't know I was going to be on it. It looks like Mr. Warner had a deferred domestic violence that he pled to on June 8th of last year, 2023, and was given 12 months of probation. So this incident would have occurred while he was on probation for domestic violence. We've had notice since approximately November, and we've talked with the victim since November when this incident occurred, so we're well aware of what's going on there. There was a bond request done on January 2nd, 2024. At that point, over our objection, bond was modified to $500 or cash or surety. Judge, I don't think there's been a change of circumstances to indicate a need for a bond change. I think $500 for is essentially what works out to be a 10-year possible felony, since it's a aggravated DV second with a third habitual would be a 10-year max. I think $500 is more than reasonable. This occurred while the defendant was on probation to the district court for domestic violence. So I don't see any reason why it should be changed at this juncture.
Right. So, Mr. Murphy, with regard to bond conditions, those haven't been looked at. I believe he has to take training through, what is your name, please?
Laura Holbrook.
All right, well, I have Ms. Holbrook present in the courtroom. You can have a seat. So, Mr. Murphy, you are requesting bond conditions be lifted. That requires, typically, my understanding is she goes to counseling through Catherine Cobb, and he's supposed to do something with Mr. Bailey. He's still in custody. Obviously, I am not willing at this point to lift the bond conditions. but I also feel in light of the offense he's facing, a $500 cash surety bond is more than reasonable. So, Ms. Holbrook, Mr. Murphy stated that you have been in contact with his office. If you have input you want to make in this case, you need to go down one floor to the second floor and ask for the victim advocate and speak to them.
I spoke to the prosecuting attorney.
Why don't you come up to the podium? Nope, right there. You can just like,
Sorry.
Yep, there you go, and come up to the podium, and then if you could state your full name for me.
Laura Holbrook.
Okay.
I have spoke to the prosecuting attorney, and I've already filled out a paper stating that I want everything dropped. And I keep talking to them, and they told me I can't do nothing further.
Well, they don't have to drop charges just because someone wants to drop charges. So what I'll do, Mr. Murphy, is I'm going to set this out to February 31st. Wait, no, that doesn't look right. January 31st at 8:30 in the morning, and then you can follow up on that, Mr. Murphy.
Well, Your Honor, I guess the problem I have here is a disconnect in regards to when Ms. Holbrook is she requesting information as to how to get the no contact drop? Is she asked, because that's something, again, she needs to do more than just.
Well, I've already explained on the record what she needs to do to get the no contact lifted, but I'm not going to lift it at this point. And his bond's 500. I'm going to set this out 2 weeks. Ms. Holbrook said she spoke with the prosecutor, but just because the victim asked for charges to be dismissed in a domestic does not mean that the prosecutor has to. So I'll set this out 2 weeks for you to meet with the prosecutor on this case. And then Mr. Warner, we'll see you back on January 31st at 8:30 in the morning, all right?
Can I say something? I have talked, the prosecuting attorney told me to call John Bailey, and I called John Bailey to get the no contact drops, but I have to wait until Mr. Warner gets out of jail.
And I don't know that I'm not letting him out today. His bond's 500. So we'll see you back on January 31st at 8:30 in the morning. All right. All right. Thank you.
Thank you, Ms. Holbrook, for coming. Thank you, Your Honor.
Thank you. And Mr. Warner, you're all set.
Thank you, Your Honor.
Thank you.
Everyone have a good day. Thank you.
Thanks, Mr. Murphy. Hi, this is Judge Anselone. I don't think he's on the middle floor, but I'll see Mr. Tate. I think he's probably down on the first floor. Mr. Tate.
Yes, ma'am. Let me get a hold of them and let them know.
Awesome. And can I close out my room too, or will they be using that room too?
The one you were in with Mr. Warner?
Yes, sir.
We can get that closed out for you.
I'll close it out. Thank you.
Absolutely.
Bye-bye.
Bye.
Okay. All right. So Mr. Malaro, bear with me for 1 minute. I wanted to check a trial date. Hold on. Mr. Malaro, do you represent Emily Smith?
Maybe.
Okay.
Let me look.
Okay.
Yes, I do.
Right. She is scheduled for a pretrial next Wednesday. Okay. So hold on. Aaron Lambus pled out.
I have her for the 31st, Your Honor.
Yeah. You know what? I thought you had a trial that week. You don't. So you're all set, Mr. Malaro. Thank you.
I have a trial. You mean next week or the week after?
No, I'm good. I'm good. I just had to check a date. You're all set.
So I'm not in trouble?
You're never in trouble, Mr. Malaro. All right. Mr. Johnson, you want to go stand at the podium? All right. This is in the matter of files, the people of the state of Michigan versus Darnez Donald Johnson. We have 4 files, 22-20959FH, 23-21542FH, 21543FH and 23-21544FH. So I have Rhonda Underwood appearing on behalf of Mr. Johnson, and Mr. Johnson is present in person from the Michigan Department of Corrections. Miss Underwood, Mr. Johnson, I had you scheduled in person so we could get your fingerprints. So I apologize for the ride today, but
it was also a great opportunity for us to talk.
Right. So Miss Underwood, how would you like to proceed on behalf of Mr. Johnson?
Well, the outlines of a plea, I believe, have been there, and I just tried to firm this up, and I'll see if Mr. Fleming can,
well, actually, let's see if Mr. Fleming can put it on the record.
Well, let me see if this is, because I discussed pleading and dismissing certain counts. On Johnson, is the plea bargain on 959, count 1, dismiss count 2, and the subs. Case 542, as charged, no subs. Dismiss 543 and 544, the most recent cases, and that is everything for Mr. Johnson that he currently has.
That's
Mr.
right.
Fleming?
Yes, you pleaded those 2 counts, we would dismiss the remainder that
I'm
are.
sorry?
Hold on, Mr. Fleming, we're getting a lot of feedback and I apologize. The audio in this building has been awful today. So Mr. Fleming, is the plea offer on file number 959, plead to count 1, no subs, 542 as charged, no subs, and nolly pros the other 2?
Yeah, and dismiss count 2 in the first case as well, Judge.
Okay, that's correct.
And that I don't believe, Mr. Fleming, that he has anything further in district court.
I don't see anything outstanding.
Thank you. Okay. And Mr. Johnson will, and we would also request a COBS to the low end of the guidelines, Your Honor.
That's fine.
And Mr. Johnson will accept that offer.
All right, so Mr. Johnson, thank you. All right, so no subs. Okay. All right, so Mr. Johnson, you want to raise your right hand for me as best you can. Mr. Johnson, you all right? Okay.
Can you?
Oh, you gotta, can you just put your fingers up?
Can you?
The other one. Do the other one for me real quick. There you go. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Yes. All right, thank you. Sorry about that, Mr. Johnson. All right, can you state your full name for the record?
My name is Donald Johnson.
Okay, so Mr. Johnson, you've heard the statement of your attorney and the prosecuting attorney. The plea offer on file number 22-20959FH is to plead guilty to count 1, assault of a prison employee, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine, with count 2 being dismissed, as well as your habitual offender 4th offense notice. So is it your intention to plead guilty to that file? Okay. And then on file number 23-21542FH, is it your intention to plead as charged to count 1, assault of a prison employee, which carries a 5-year maximum as well as a $2,500 fine? Okay, and Jeff, can you move the microphone for him? No, I'm going to move the microphone towards you a little bit, Mr. Johnson. Okay, and you understand on both of those files, the maximum penalty could be up to 5 years in prison. And Ms. Underwood has asked for a COBS agreement that your sentence would be from the low end of the guidelines to whatever the maximum is. So if your guidelines are 10 to 23 months, your sentence would be 10 months to 60 months. Yeah, because your cap is 5 years. You understand that? Okay. And then do you understand, because you're currently incarcerated, these would stack on whatever sentence you're serving now? Okay. And Miss Underwood, would Miss Underwood and Mr. Fleming, would these two be able to run concurrent, but they would be consecutive to what he's serving now?
I believe they would probably be concurrent. Let me Let me check on that, Judge, just to be safe. Let me come back to that.
I know they're concurrent to what he's currently serving, but 717, 1012. I think the court has discretion to sentence these two concurrent to each other, but consecutive to what he's currently serving.
Can you say that one more time? I just want to make sure I'm understanding.
So I believe if he enters a plea on these two files, when he's sentenced, I can sentence these two files concurrent. But it would be consecutive, stacked on what he's currently serving.
It is absolutely consecutive to what he is currently sentenced to prison on. I think there may be a possibility. I'm not sure whether or not they technically could stack, but I will tell you what, I have no objection if this court wishes to cobs it to running concurrent to one another.
Okay. All right. So do you understand when you get sentenced on these two files, they would be served together, but it would be stacked on what you're currently serving? You understand that? Yes. Okay. All right. Okay. Are you satisfied with Miss Underwood as your attorney and the advice that she's given you? Okay. So I'm going to need you to speak up loud just so we record. So we got to be able to pick it up. Okay. Okay. And you're very soft spoken, so that's fine. Now, other than what was placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
And Mr. Fleming?
That's correct, Judge.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have heard at trial. I'm going to explain those rights to you now to make sure that you understand them, okay? Okay. Are you picking that up, Ms. Spade?
No.
Okay. You really, this is like the only time I'm going to tell you, you get to yell at me.
Yes, ma'am.
All right. Good job. All right. So you have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Okay. And if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. You understand that?
Yes, ma'am.
Now, I notice we have people sitting over here, and she is an intern. She's not from the Michigan Department of Corrections or anything, okay?
Yes, ma'am.
Okay. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right. So, Mr. Johnson, on file number 22-20959FH, how do you wish to plead to the charge that on or about July 17 of 2021 in Adrian Township, I'm going to guess at Gus Harrison, that you did commit the, and that's in Lenawee County, that you did commit the offense of assault of a prison employee? Guilty or not guilty?
Guilty.
Okay. And then Mr. Johnson, on file number 23-21542FH, how do you wish to plead to the charge that on or about October 12 of 2022 in Madison Township in the county of Lenawee, which is the other half of Gus Harrison facility, that you did commit the offense of assault of a prison employee? Okay, and that's located as well in Lenawee County, right? Okay. Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No.
And Mr. Fleming?
No, Judge.
All right. Has your attorney promised you any particular sentence or estimated what your sentence would be other than the low end of the guidelines?
Yes, ma'am.
She has? Is that what she told you they would be?
Yes.
Did she tell you anything else?
No.
Okay. Is it your own choice to plead guilty to these charges?
Yes, ma'am.
All right. So Mr. Jensen, let's go to file number 22-20959FH. So Mr. Jensen, on July 17th of 21, were you in Adrian Township in the county of Lenawee at Gus Harrison facility?
Yes, ma'am.
Okay, and at that time, did you come in contact with a correction officer named Chase Byers?
Yes, ma'am.
All right, and you assaulted him in some way. So you could have used violence in any way, pushed him, pulled him, punched him, spit on him. You could have threatened to hurt somebody. You could have had a shank. Tell me what you did to assault that prison correction officer. You threw urine on him? Okay. And would you agree that he would find that to be an assault?
Yes, ma'am.
Okay. All right. And you were lawfully incarcerated at Gus Harrison at that time, correct?
Yes, ma'am.
Are you satisfied, Mr. Fleming?
You are satisfied with that count, Judge.
All right, so then, Mr. Johnson, on file number 23-21542FH, on October 12th of 2022, were you in Madison Township at the county of Lenawee at the Gus Harrison facility?
Yes, ma'am.
And I think it's a different township, but isn't Gus Harrison kind of like between townships or no? No, so it's Madison Township. So Mr. Fleming, the felony information on the other file is wrong.
I would agree with that, Judge.
Will you fix that?
I will, absolutely.
All right, thank you. So would you agree you were at Gus Harrison in Madison Township?
Yes, ma'am.
Okay. So at that time, did you come in contact with a correction officer named Franklin Washburn?
Yes, ma'am.
Okay, and so and you were lawfully incarcerated there, you were sentenced there, correct?
Yes, ma'am.
Okay, so can you tell me what you did to correction officer Washburn?
Same thing I did to Byers, man.
Okay, so it's a completely different date, but you threw urine on him too.
Yes, ma'am.
Okay, would you agree that correction officer Washburn felt that that was an assault?
Yes, ma'am.
Okay, Mr. Fleming?
I believe that's been satisfied as well, Judge.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
And Mr. Fleming?
Absolutely.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court, other than cobbing to the low end of the guidelines, had made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to set this for sentencing on March 22nd at 8:30 in the morning. So, Mr. Johnson, you do have the right to be present in person for sentencing. Do you understand that? But you also have the right to Zoom if you want to. So, do you want to be in person or via Zoom?
Zoom, please.
Zoom? Yeah. Okay. So, Mr. Johnson, somebody from the correction or the probation department is going to reach out to you and they're going to update your prior pre-sentence report, be truthful with them about the events that occurred and also your background. Do you understand?
Yes,
they'll get that report to us. We'll provide a copy to Miss Underwood. Miss Underwood's really good about getting in contact with inmates at MDOC, but sometimes there's different things going on and she can't reach out to you. If she isn't able to review it with you beforehand, I will give her time to review it that morning, okay?
Yes, ma'am.
So Mr. Johnson, when I look at your record, you know, you have, I mean, you've probably served your time on all your original offenses. So basically, you're just serving time now on your prior prison employee assault, right? So Mr. Jensen, I want you to really think about, before you come to sentencing next time, what you can do and what you need to be able to be there and not get in trouble. Because if you keep getting these, you're never gonna go home. All right? So you think about that, and when we're here for sentencing, you tell me what you're gonna change, okay? All right, so we'll see you back March 22nd at 8:30 in the morning via Zoom. Thank you, Mr. Jensen.
What day is March 22nd?
March 22nd is a Friday. Do you not like Fridays?
Friday's all right.
All right, is 8:30 in the morning okay?
Yes, ma'am.
Okay, so I'll see you back March 22nd at 8:30 in the morning, okay? And you behave. Okay, all right, you're all set. You can go. Thank you. I don't think you can get it. There you go. All right, thank you. Okay. I do. I have one friend of the court pickup. I don't even know. I'm not gonna be able to do it this morning. I'll figure it out. All right, Miss Tamaris Hennigan, Mr. Tate, good morning.
Morning.
All right, this is in the matter of the people of the state. Ms. Hennigan's gonna represent Mr. Tate.
Okay.
We'll call you this afternoon. Huh? I wasn't on my docket. It got moved.
You didn't have him on docket?
It got moved.
Oh, okay.
Okay. All right, this is in the matter of the people of the state of Michigan versus Harold Glenn Tate Jr., file number 22-20934FH and 22-21132FH. Mr. Tate, we're here on a violation of probation. And did you receive a copy of the request and warrant for probation violation, Mr. Tate?
Yes, ma'am.
Okay,
Yes.
so Mr. Tate, Mr. Tate, it's alleged that you violated the terms of your probation and that contrary to condition 1 on the order of probation dated January 12 of 23, you pled guilty to possession of analogs in Hillsdale County on January 8th of 24. And do you understand on your charges, a violation of probation could carry on file number 22-20934FH, a maximum penalty of up to less than 20 grams firearm possession. So it looks like got an amended information. Let me find an amended information. Let me find it somewhere. Hold on. Mr. Jones doesn't coddle me and put the max penalty on him for me. So he pled guilty to possession less than 25 grams, second offense. I know that's a 20. Oh, here we go. So the maximum penalty if you pled guilty or found guilty of these violations of probation could be up to 8 years in prison on this file. And then on file number 22-21132FH, if you plead guilty to the violation of probation, again, the maximum penalty could be, if I'm correct on this, there's my judgment of sentence. I think it's also 8 years. So, Mr. Tate, you do have a right to have an attorney represent you on this and all subsequent cases. And Ms. Hennigan saw your name this morning and said she would be coming in to represent you. Do you want Ms. Hennigan to represent you today?
Yes.
Now,
Yes.
Ms. Hennigan, you represented him. You were retained previously, is that correct?
Yes, Your Honor.
Okay, so Mr. Tate, you want Ms. Hennigan to represent you today?
Yes.
All right, so Ms. Hennigan, when's your sentencing date in Hillsdale, Mr. Tate?
What is my what?
March
Oh.
It was for me, sis. March the 4th.
March 4. All right, so he is set for sentencing on March 4, Ms. Hennigan. Do you want a moment to talk to Mr. Tate?
Yes, please.
Okay, so Mr. Tate, I'm going to open a breakout room for you and Ms. Hennigan to chat. And hold on. So I'm gonna put Ms. Hennigan and Mr. Tate. All right, he's automatically gone. All right. So I have Johnson. All right, in the matter of, all right, Mr. Fleming, I think I'm all set with you today, am I not?
I have no idea, but I'll take that. Thanks, Judge. Have a good day.
All right, Mr. Malaro, I think you're good too. All right, so in the matter of Ashley Schlussler and Larry Schlussler versus Narayana Belakonda, MD, Bixby Anesthesia Associates, PC. File number 2017-5947 and H. I have Matthew G. Curtis, P37999, appearing on behalf of the plaintiff. And Robert Horde, you're coming in for Keith Felty, is that correct?
That's correct, Your Honor.
And what's your P number?
73328.
All right, and then Lenore Zackham, what's your P number?
84664, and appearing on behalf of the plaintiff with Mr. Curtis.
Okay, very good. All right, so I set this over today because we had some jury trials scheduled and we had to adjourn the trial date due to things beyond all of our control. It was a witness issue, an expert witness issue. How is the expert witness? Good?
Yep. All our experts are good, Your Honor.
Okay, all right, because I know there was concerns. All right, so we then have set the jury trial. Let's see, we adjourned it from the 31st, right? To when did
we adjourned it from the 16th to the 30th.
Okay, so I have the 30th. January 30th is a Tuesday. So yep, so it's one day of 4. Darren Baker was a jury trial that got adjourned. Aaron Lambus was a criminal jury trial that pled out. So that's taken care of. So we don't have to worry about that. And I have no other jury trials that week, thank goodness. All right, so as of today, we are ready to proceed then on January 30th. Mr. Curtis?
Yes, we are, Your Honor.
And Mr. Horde, okay. So this is a 4-day jury trial that was scheduled previously, and we had some discussions beforehand. Have the parties been able to meet and review the jury instructions, Mr. Curtis and Mr. Horde?
So I sent right after we had our last conference, I immediately sent over our proposed jury instructions to Mr. Felty. Mr. Horde has just come in recently, and I don't know if he's taking over the bulk of the trial or is going to be the main trial attorney. Are you, Robert?
I'll be doing a big part of that. I've looked at the jury instructions, the preliminary instructions.
Mr. Horde, we're having some. Mr. Horde, so here's what I'm going to do. I'm going to turn off. You're really breaking up. So I'm going to stop my courtroom video. It's so cold that everybody's internet is kind of wonky. And Ms. Zackham, are you going to speak today or are you just watching?
Not, Your Honor, I'm just watching.
Okay, I'm going to stop your video too because that helps broadband. All right, so Mr. Horde, can you repeat your response, please?
Yeah, at this point, I've gone over the preliminary jury instructions, Your Honor. I don't really have any questions or concerns there. I just had, I think, a few additions to the post-proof jury instructions, particularly 30.04, which is the cautionary instruction on adverse results, not necessarily malpractice. I think that's something we're entitled to get. But again, all of the post-trial ones are subject to proof. So at this point, I can say what my objections are, but they're all really related to post-proof stuff.
Okay, so I will say that right now I'm mostly concerned with the preliminary instructions because we'll have ample opportunity to discuss the final ones once we're all here. So you're talking about 30.4, that would be a final instruction, correct?
Correct. The only thing that jumped off the page to me with the initial instructions, and it's just something that I generally don't see done or haven't done, is 2.02 is the listing of the elements of the claims. Obviously, that's the court's discretion. It's just something that I think bogs down the reading of the jury instructions, but that's just my only.
Mr. Curtis?
I think the court rule or the rules require that, the description of the trial procedure be given, including the description of those terms. And I think it's important that the jury hears those terms before, they start hearing the proofs, because then they're going to hear them again. I mean, just to read them only one time to the jury becomes very difficult for them to comprehend everything. So, I mean, I think reading of those terms before would be totally appropriate.
All right. I don't think there's any, I don't think it impacts you negatively in any way, Mr. Horde. Okay, so that's fine. So do we have an agreement then on the preliminary instructions?
I think so.
Okay, and have those been submitted to my judicial attorney?
But I will do so this afternoon. I wanted to submit it to Mr. Horde and Mr. Felty first, and then, I was hoping if they had problems.
It's fine. Okay.
Let me know.
All right, so let's talk about this. So, what your questions, have they been exchanged and submitted?
Yeah.
I haven't seen them from plaintiff. I have some done, Your Honor, that I'll get over to Mr. Curtis after we get off
I have mine done also.
Okay, so let's talk about voir dire. My intention is we will set a jury by noon. All right, I do the majority of the voir dire. I will ask some of the questions and I will ask the questions that you provide to me as long as there are no objections and I don't object to them. And then I will allow follow-up questions by you. But we do not spend a day doing jury selection. My docket control, I have that authority under docket control. So I would ask that you all be here by 8:30 in the morning so that we can chat and be ready to go right at 9 to bring the jury in. And it's my hope that we'll seat the jury. I'm a quick reader, so I assume that we will be able to give them their jury instructions. I've sat juries by 10:30. So it's a small panel. Are you asking for 6? How many jurors do you want?
6.
Generally, I would have.
I mean, sometimes you have an alternate.
Are you talking over each other? So hold on a second.
Go
So
ahead,
I
Robert.
do pick, because it's a 4-day trial, I'm probably going to recommend at least 1 or 2 alternates. I know COVID's like in the past, but we've had jurors get sick with COVID and not be able to, well, flu too, but COVID's pretty rampant right now in the county. So I would suggest alternates. So Mr. Curtis, you're asking for 6?
No, Your Honor, I have no problems with with 1 or 2 alternates. That is just fine. And then in the end, we'll make a decision whether we keep them or we, dismiss them.
Okay, my question was, you want 6 plus alternates?
Correct.
Okay, and Mr. Horde?
Yeah, that's
okay.
Perfect.
So we'll need 6 jurors and we will pick, let's pick 2 alternates. I hate to do it, but so we'll have a total of 8 jurors. Okay, and only because, like I said, the rates are pretty high in the county right now and weather too. So, all right, so we'll pick a total of 8 and then at the end, we'll draw 2 to release, okay? And we may change that to 1 when we talk the first day, that's fine. All right, so, so then my assumption is jury instructions before noon or at 1:30, we break from 12 to 1:30. Our staff is entitled to 2 15-minute breaks and 1 hour lunch. With juries, it works much better because it gives them time to actually go eat and get back in time. So we break from 12 to 1:30. Worst case scenario, I'll do jury instructions then, and then we'll move right into opening arguments. And hopefully, we'll be able to get our first witness on that day. So I think we talked before, Mr. Curtis, you were asking for about 45 minutes for opening statements.
Correct.
And then Mr. Horde.
Yeah, that's fine.
Okay. All right, 45-minute opening statements. Most people don't use that, but okay. All right. All right, so potentially we may be able to get the first witness on that day. Closing arguments. So if we give, that's a half day on Tuesday for Mr. Curtis, and then Wednesday we start at 10:30 because I have a criminal docket. And as you can see, I have an extensive criminal docket because I'm still not done with it yet. We started at 8 o'clock this morning. So we start at 10:30 on Wednesday, and that'll be Mr. Curtis. So he's gonna have most of the half day on Tuesday. He'll have the majority of the day minus about 2 hours on Wednesday. So that gets us into Thursday and Friday. My intention is closing statements Friday afternoon. Mr. Horde, your predecessor, said he probably only needed about a day and a half or less.
Yeah, Mr. Felty's still going to be involved in trying the case. So yeah, that's my understanding is we'll need about a day and a half or less.
All right, so you guys both get about a day and a half, a little bit more to the plaintiff, obviously, and then closing statements, limited to, I was thinking 45 minutes, Mr. Curtis, but obviously you get 2 bites at the apple. 45 minutes, Mr. Horde.
45 minutes to an hour. And to be honest with you, Judge, this could run up very close to, the end of the day on Friday.
Well,
and it would
but
be
I'm going to tell you,
shame
but I'm telling you that plan accordingly. So worst
to- I
case
understand,
scenario.
but when we did talk last time, you did say that your Monday had canceled, the following Monday had canceled,
Right.
and that we could
So,
go over to that Monday if need
But
be.
plan accordingly, because I don't want to be taking witness testimony that Monday. You know what I mean? Worst case scenario, we can do closing arguments that Friday morning or the 5th on the morning.
Monday morning, could that be perfect?
Yeah, so I have the 5th available with some minor hearings, but I don't want to be in witness testimony at that point. Worst case scenario, we'll do jury instructions and closing arguments, but I don't want you to count on that. I like to keep the trial moving. I know it's, it's not the most complicated trial we've ever done, but it is a complicated trial. So I do have that Monday available to bring the jury back for deliberations, and we can do worst case scenario closing arguments and jury instructions, or one or the other. So I will keep the trial moving. So, so 45 minutes for closing statement, Mr. Curtis, and then of course you'll get another bite at the apple as well.
Right.
And then Mr. Horde, is that good for you? Okay. In closing plus minutes. Okay, so I think that's good. All right, so jury instructions are coming in today, and you're gonna get me the voir dire questions too today or this week, at least by tomorrow?
Yeah.
Or I give you to Friday to get me your jury and voir dire questions. Because I'll put them.
I am shaking it.
I know, you gotta acknowledge with a verbal, please.
Yes.
Okay, all right. Okay, so anything else?
Your Honor, if I can make it tomorrow, is it all right if I come to the courtroom and kind of check out the technology situation? So I'm ready to go.
Yeah, you guys are free. We don't have any. So there you go. You can use an HDMI cord to plug into our Polycom monitor. So there's a big screen on the courtroom wall. It's like not as big as my husband's, but it's like a 45, 50-inch. It's the Polycom the state gave out of the courtrooms. Some attorneys bring in their own stuff. You can bring in whiteboard. We do have like a chalkboard with a whiteboard on the back that you can write on, but you can also bring in your technology. I will tell you that we accommodate you. So anything you bring in, you can leave it here. We lock the courtroom. We can lock it in back so you don't have to lug your stuff out every day. Okay. But yeah, you're more than welcome. We're here all day, Thursday and Friday. So, or next week we're here too. So you're more than welcome. Okay, just give Miss McGrain a heads up, you're coming and we'll make arrangements.
Thank you.
Before we sign off, sir, and we're not on the record, right? Robert, can I just have your cell phone number?
We are on live on YouTube. Do you know how to chat it, Mr. Horde?
Sure.
All right, he's gonna send you that number via chat, okay?
Ready?
Oh, I lost her. Okay. All right, he's sending it via chat. Sorry, Miss Zachary, I didn't notice you got bumped.
No, that's okay.
Got my number, Matt.
Yeah, got it. Thanks.
Very
I'll
good.
call you right after
Perfect.
this record.
I'll see you guys later. Thank you.
Very good, Jess. Thanks a lot. Take care.
Thank you. All right.
It's back on. Now I need the camera.
Mr. Tate,
Yeah.
they turn the light off on you?
No, they got the camera turned around. I don't know how to work this stuff. And
Okay.
they talking about to give them a minute and stuff like that.
Okay. So Ms. Hennigan, what were you gonna want to do with Mr. Tate today?
Thank you, Your Honor. I would like to have these probation violations set for hearing. Enter a plea of not guilty for now, set them for hearing, and then if allowed, I would also like to address bond for Mr. Tate.
Okay, okay, so Miss Adams, I have the book, so you need, how far out do you want this adjourned, Miss Hennigan?
Even just 30 days out should be sufficient, Your Honor, so I can get to meet with Mr. Tate and prepare.
Thank you.
So I could set this for Amy. February 22nd at 8 a.m.
So February 22nd?
Yep, 222.
I have a 9 a.m. hearing in Judge Sal's court that morning, Your Honor.
You'll be done by 8:45.
Okay.
Okay. All right, so I enter a plea of not guilty. We'll set this for 8 a.m. on 2224. So February 22nd of 2024 at 8 a.m. And I have Sarah Teskey here, and I do not have Chris Jones here. I do know that Chris Jones may have opposed a bond, Ms. Teskey.
Your Honor, he indicated to me that due to his pending charges in Hillsdale County that he does not recommend a bond at this time.
And I typically do not give bonds on violation of probations when they commit a new offense while on probation.
Understood, Your Honor.
All right, so.
Judge, I'm sorry.
Who said that, Ms. Adams?
Yes, I was just gonna ask if that was a hearing we need the prosecutor for.
Yeah, is it gonna be I don't think so, no. All right, so what I will tell you is I will set his bond at 1,300 cash. That's his fines and costs, I'm willing to do that. All right. And then do you want me to make it closer, Ms. Hennigan, and a sooner date?
No, Your Honor, he also has a hearing in front of Judge Morgan later this week, so I don't think.
If something changes, Ms. Hennigan, and you want to request a change, you can always let Ms. Adams know and I'll get Mr. Tate in right away.
Thank you, I appreciate it.
Okay, all right, Mr. Tate, I'll see you back on that day, all right?
All right.